You are listening to PowerScore's Law Practices podcast series. Today's practice is contract law. On the program today, we will hear from 3 professors that teach contract law at their respective law schools. We have Frank Snyder from Texas Wesleyan School of Law, Brian Bix, University of Minnesota Law School, and Stephen Schooner from George Washington University School of Law. Professor Snyder starts his comments by defining contract law and says it's an unusual part of the legal system.
Contract law is one of the most unusual parts of the legal system because almost all of the obligations that we have put upon us are mandatory. We don't have any choice in the matter about how fast we drive on the highway or whether we pay our taxes or whether or not we dump things into rivers. But contract law is voluntary. It is the part of the law in which the government says we get a choice in what our obligations are, and therefore we make private agreements that are enforced by the government. And that allows us to do things like engage in economic activity, to buy houses, to be employed. So the whole range of private, what's usually called private ordering, is governed by contract law. And it's important not only in the business world, of course, which couldn't go on without it, but in ordinary private life as well.
Professor Schooner has a similar definition, but also says that contract law is very different from criminal and tort law.
Okay, so contract law, as a general rule, deals with bargains. So one way to think about it is to distinguish it from criminal law, which is where the state basically defines behavior that is acceptable and unacceptable, and the state enforces breaches of that behavior. Okay, so that's criminal law. And then torts is a different animal because bad things happen to people who may or may not have relationships. And that's torts its own thing. Civil procedure is a procedural course. Conceptually, the Constitution deals with how the government functions, and property is basically what's yours and what isn't in terms of things that move and things that are fixed in one place. Contracts, on the other hand, begins from the premise that, at least in our society, you're entitled to do pretty much whatever you want with what's yours, with your human capital, your property, your energies, your intellectual capacity, and the like. And the theory is that we believe that society functions best if in the future you can make bargains that benefit you and possibly the other party as well, and rely on those bargains. So the example I often give my students, by the way, are you taping or am I just going too fast, or does it make a difference? Okay. Okay. So if you think about a world without contracts, if you're a farmer and I'm a farmer and you raise chickens and I grow grain, and you and I don't trust each other and we have no enforcement mechanisms, and we want to trade grain for chickens, then you're going to stand there with your hand around your chicken's neck, and I'm going to stand there with my hand around my bag of grain, and we're going to simultaneously put our hands on each other's property and let go on the count of 3. And that's one way we could do business. Now, I could promise that I'll give you my chicken now and you can give me your grain later when the grain comes in, but the question is how and why would I rely on that? And then if you don't make good on it, what am I supposed to do? You know, the alternative is self-help. I can go and burn down your farm or beat you to a pulp or whatever, or just physically take what I think is mine. What contract permits parties to do is enter into bargains so that they can basically exchange anything. And the bargain, what contracts begins with, is figuring out what is an enforceable bargain, and then it moves into trying to figure out what bargains are we going to permit people to escape from, and then The latter part of the course is all about when parties do have enforceable bargains, what do we do when the parties disagree over what the words mean? So that's contract interpretation. And then what do we do when one party doesn't really fulfill their promise? Because a classic bargain is an exchange of promises between two people. And then the last thing is, to the extent that one party might breach, what type of damages are available to make the other party whole? And as a general rule in contract law, the only damages that we really care about are money damages. Again, this distinguishes it from criminal law. Nobody goes to jail in contracts. That doesn't mean there's no crimes that are related to contracts, but as a general rule, money fixes everything in contracts.
Professor Bick says the practice of contract law is a good specialty to understand for many other specialties within the legal field. And since you are required to take the course in your first year of law school, you will be able to know if it is something that interests you very quickly.
Well, contract law really isn't a specialty as such. Contract law is a mandatory first-year course, which means it's there as much just as a sort of tool or excuse to help teach students generally about how to read cases, how to reason, how judges and lawyers reason, than it is to teach you the details. Now, that said, it's not so much that contract law is a specialty as much as it is something you need to know for many other specialties. If you go into real estate law, if you go into sports law, if you go into corporate law, if you go into family law, there will be occasions for you to need to know the basic principles of contract law, but you'll need to know a lot more than just those.
Professor Bix goes on to say that you won't learn much about the practice in undergraduate courses, but law school will definitely help prepare you.
Undergrad, there's nothing special you do to prepare for contract law. There are things you can do to prepare generally for law school. It's good to have take a lot of writing or composition courses. It's good to take logic courses. It's good to take courses that help you think analytically, whether they be in philosophy or political science or history or even English. The notion that you should take courses in constitutional law or something like that, I think, is overstated. I think it's better just to retain the sort of writing, analysis, and persuasion skills that'll be valuable generally in law school.
Professor Snyder continues by saying that if you're interested in contract law, know that it is practical, and you should always know what your clients need.
If you're interested in doing contract law, what you discover is that it is a very practical kind of field. And the most important thing in contract law is to understand what your clients need, because you could think about contract law as a kind of a toolbox to achieve what it is your clients want. So the first thing you have to do is focus on what they need. And so it's a very people-oriented field of law. It's one in which you have to be able to communicate with your clients, determine the kind of deal that is in their best interest, think about protecting their interests, and then go into the toolbox and use all the various things that you've learned in law school and that you can come up with when doing research to try to figure out how best to structure the transaction that they're involved in. Now, that's if you're doing the transactional side. From the litigation side, you'll always be dealing with situations in which deals have been broken. Somebody delivered something and didn't get paid. Somebody delivered something and it didn't work. Somebody tried to buy a house and they now can't get it. And in that situation, you need to understand the basic toolkit to figure out what the obligation was, whether it was breached, and most importantly, what remedies are available. I mean, what can you get for your client? So the contract law can be practiced at a number of levels. At a very high level, there are, I say high not in terms of better or worse, but in terms of complexity. At a very high level, there are contracts for building oil refineries the Persian Gulf, for example, in which there are hundreds of parties concerned. There are thousands and thousands of issues that come up. At the other end, there are relatively simple consumer-type transactions. But then there are, if you're doing family law, of course, there will be settlements, property settlements, any kind of litigation. There'll be contracts to dispose of litigation. So it's one of those fields where the range is almost limitless of what you can be doing. And therefore, if you like working one-on-one with consumers, it's a great field. If you like using your brains to put together extremely complex transactions, it's also a field that can allow you to do what you want to do.
Professor Schooner says that students either consider contract law boring or not. He also says if you find business and bargains fascinating, this might be the practice for you.
My experience is that students come to contracts thinking it's going to be boring and find it's not. So the first thing they should know is just because they're not familiar with it doesn't mean it's boring. Second, business of all kinds and transactions tend to be fascinating if they think about them, and they engage in them all the time, but they don't think about it. For the younger students, many of them, the most sophisticated contract that they've entered into was their mobile phone contract, which they didn't read, but has a lot of really interesting terms in it. They also, almost all of them, have a charge card, which has a complicated contract that they didn't read. And then, the older students tend to have purchased a car, maybe taken out a car loan. Some of the older ones will have even had a home loan. And it's basically just understanding that these contractual vehicles, these written agreements, are written by people with an eye towards anticipating contingencies, so they know that in life things go wrong. And so accordingly, they've come up with remedy-granting clauses. They've come up with pre-negotiated solutions to likely problems that will arise while the parties are dealing with their transactions. But the bottom line is, in life, you constantly make bargains. You constantly wish to exchange value with other people and other businesses. And the more that you understand these things, often the more productive you can be in your life, but it permeates literally every field of law, which is one of the reasons almost all law schools teach it in the fall of the first year.
He continues by suggesting that students read contracts to prepare and understand the terms that they will see in everyday contracts.
Well, the first thing that I think most professors tell students is to read contracts. Most students go to law school with, for example, a laptop computer. Most of them will have purchased it online. None of them will have read the contract that they signed when they bought the computer or the shrink-wrap contract that they received in the box when they got the computer. But just being aware of these things, reading the contracts and trying to figure out the terms is, really the beginning, because the biggest shock or change for most normal humans when they begin law school is understanding that reading is important and close reading is critical.
Professor Bix ends his advice by saying that to be successful in this practice of law, face-to-face interaction is a skill that is required.
Well, again, this type of law, there's a wide variety of types of laws connected with contract law, as I said, from real estate transactions to, divorce law to sports agents. In general, I guess one thing to keep in mind is that the type of law you'll be doing if you're interested in some sort of contracting is a lot of face-to-face negotiation. So developing negotiation skills, whether as an undergraduate or at law school, and just the sort of human personal interaction skills that are not always directly rewarded on LSAT or grade point averages, but which are very important when you get out into the world, are useful to develop.
Professor Snyder advises that students understand lots of other areas of law, and that if you can advise for a business, you will be very successful.
If you're going into in law school, let me put it this way: what could you do in law school to get ready for this going out into the world? It's very important, if you are going to be an advisor to business, to understand a lot of different areas of law. If you are representing, for example, a small or even a medium-sized family business, and there's some very large family businesses, you need to understand the basics of tax and securities laws and estates and trusts, and probably real estate law, and probably zoning, and administrative law, because all of those issues will be involved in advising a business. And one of the things that I find is that while people say there is a glut of lawyers in the country, there are really not very many lawyers out there who are capable of acting as advisors to businesses on a regular basis, because they tend to specialize. So I would recommend to law students that they take all of the business courses that they can, especially those in tax and securities and business transaction law, because your client's problems will not come to you as, I have a current dispute over a contract. Can you help me resolve it? Or I'm about to do a deal and I want to have a contract written up. That's not the way it works. What it comes to you is your client says, I'm thinking about doing this. What should I be thinking about here? How should I be doing it? And therefore you need to be aware of the entire range of issues that business can be involved in. And so I recommend that you take just as broad a business curriculum as you possibly can. And that will prepare you for practicing law, either helping consumers who've got themselves into bad transactions, or, helping giant corporations to build, enormous projects overseas.
Finally, Professor Schooner suggests that students not be afraid of numbers or mathematics to practice contract law.
Don't be afraid of mathematics. Just because numbers are involved doesn't mean that, a lot of our students think that they went to law school because they couldn't do math or science and their parents wanted them to go to med school and they didn't like that, so they went to law school. But I'm fascinated that students run away from damages issues because they think that anything that involves numbers is mathematics and therefore is over their head, and that's really disingenuous. So not being afraid of numbers, I think, is a really, really good thing. Reading the newspaper, particularly things like the Wall Street Journal, I think is really important. Understanding that bargains can be immensely complicated and trying to figure out what people want out of bargains is a great idea.
Thank you for listening to PowerScore's podcast series. If you want more information on PowerScore's podcasts or services, please visit PowerScore.com, or you can call 1-800-545-1750.